I think we'll now move into the formal welcomes.
Hello everyone. My name is Carlos Vasquez, and I'm the Associate Dean for Graduate and International Programs here at Georgetown. And it's my pleasure to welcome all of you to this exciting event. This is our third in our series of comparative constitutional law conversations, comparing the role of the highest courts in the world's two largest democracies. Both India and the United States have independent judiciaries, and their Supreme Courts are among the strongest in the world. This conversation series was begun as a collaboration between Georgetown University Law Center and the Society for Democratic Rights, an organization that was started by two Georgetown alums in New Delhi. Vibha Datta Makija and Kashi Janeja. SDR is a New Delhi-based collective of lawyers who are involved in the strengthening of democratic and civil rights. It's now my pleasure to introduce one of those Georgetown alums, Vibha Datta Makija, who is the true mastermind behind this series, along with her partner at SDR, Kashish, and my predecessor as Associate Dean, Madhavi Sunder. Vibha will introduce the first of our two distinguished jurists, the Chief Justice of the Supreme Court of India. But first, a few words about Vibha. Vibha graduated from our LLM class of 1992. She has been a designated senior advocate at the Supreme Court of India since 2013. She was only the third woman to be designated in this position since the Supreme Court's inception in 1951. And at the age of 45, she's the youngest woman to be so designated in the court's history. She's also a member of the Executive Committee of the Supreme Court Legal Aid Committee, a member of the Board of Examiners of the Supreme Court's Advocate on Record Committee, and most importantly, she is a member of Georgetown's Asia Law Alumni Board. I could spend a long time listing Vibha's accomplishments, but that would leave us with little time for the conversation that she was so central to organizing. So without further ado, let me hand the mic over to Vibha.
Thank you, Carlos. That was more than what you should have said, but anyways. It's my greatest pleasure to invite and to have our Chief Justice, who's so dynamic and so youthful at this juncture of his life, to be here at Georgetown in Washington, sitting at the same podium as Justice Breyer, who's been an inspiration, not just for American jurisprudence, but for Indians as well. Just a little bit about Chief Justice Chandrachud. He hails from a family which kind of sets records, I think, just on a regular basis. So his father was the longest serving Chief Justice of India for almost 7 years. And Chief Justice Chandrachud himself is going to be setting a record for being the longest serving Constitutional Court Justice in India. He was, he had a short stint as an additional Solicitor General of India in 1998. And soon thereafter, he was sworn as a judge of the Bombay High Court in March 2000. He was handpicked to be the Chief Justice of Allahabad High Court in October 2013, which is one of our oldest and toughest high courts of the country. So it's actually his acumen as an administrator as well as a judicial mind that it was no surprise that he got elevated to the Supreme Court soon. So he took oath as Chief Justice of India on 9th November 2022, and he will remain in harness till one day before his 65th birthday, which falls on November 11, 2024. Now, this is a person who has experienced many diverse environments. His family hails from a smaller town in central India, but now He's gone on to do his high school education in Bombay and New Delhi, and is also a product of the prestigious Delhi University and Harvard Law School. His scholarship has earned him LLM and SJD degrees from Harvard. It's not surprising that he's a favorite guest speaker amongst all platforms that we know about. He has been invited to speak at various universities around the globe, including the Harvard Law School, the Yale Law School, the Australian National University, and the University of Witwatersrand, South Africa, besides Indian law schools. Well, it's said that it's the people who make the institution, and it is truer for him than anyone else. His progressive views are reflected in his judgments. It's no coincidence that during his tenure for the last 8 years, that the Indian Supreme Court has delivered a spate of progressive judgments. The celebrated judgment of Justice Puttaswamy versus Union of India firmly crystallized the right to privacy as a fundamental right in the Indian Constitution. He has sat on benches that decriminalized consensual homosexual relationships and adultery, and was seminal in throwing open the Sabrimala temple to mensurating women devotees who were traditionally prohibited from worshipping at the temple. Well, the Indian Supreme Court judges deal with an average of about 150 cases per week. This is not their entire year's docket, it's a week's docket for them. With this judicial workload, it is very remarkable that the Chief Justice retains a high degree of sensitivity and empathy for human disabilities, sorrows, and marginalization. His judgments have helped Indian women realize their full potential. Lieutenant Colonel Nitisha versus Union of India is a significant judgment because it allowed women to be permanently commissioned in the armed forces, something that was previously unimaginable. I must let you into a very small open secret. Like most Indians, our Chief Justice is a real IT geek. As the chairperson of the E-Committee of the Supreme Court of India, he is rapidly unfolding a digital transformation. Digital access to litigants and lawyers is now available in the network of about 22,000 courts across the country. Today, a litigant in the deepest of the interiors, a mensurating lady, a nursing mother, or a handicapped lawyer can easily access the court without navigating entry barriers. While his personal views on gender rights are clearly known, the ruling on the same-sex marriage, delivered a day before he embarked on his journey to Georgetown, is a clear reflection of the unenviable task of steering decisions that would meet the aspirations of people. We now have a verdict with many opinions, which in his own words, and I quote, has a degree of agreement and there is a degree of disagreement on how far one has to go. I welcome our Chief Justice to Georgetown Law here in Washington. I also want to introduce to you the person who has made the meeting of these two stellar guests possible at this stage, and that's Dean Traynor, the force of Georgetown Law. He's the Executive Vice President of Georgetown University and the Dean of the Law Center. He holds the Law Center's Paul Regis Dean Leadership Chair. Bill is named as one of the 10 most cited legal history scholars in the United States by the University of Chicago Law School's Brian Leiter. And of late, he seems to have acquired a kind of a reputation of having his writings quoted in US Supreme Court decisions. Georgetown Law has undergone a rapid transition from 2010, when he agreed to join as the dean. His vision and leadership has been so tremendous that he was reappointed to serve a third term beginning July 1st, 2020. Bill's commitment to academic excellence has made Georgetown Law hire 69 new tenure track faculty members, tripled the number of experiential offerings for students in its clinical, externship, and practice programs, and more than doubled the financial aid. Now, Georgetown Law has also experienced its most successful era of fundraising, culminating in nearly 80 million in giving in the last fiscal year. In 2012, he was recognized by the National Law Journal as a champion because of his work to uphold the profession's core values, and the National Jurist magazine has named him one of the most influential people in legal education 4 times. Bill was elected into the American Academy of Arts and Sciences for Law and Education as part of its 2020 class of new members. Most recently, he was selected for the inaugural Honorable Robert A. Katzman Award for Academic Excellence by Burton Awards. Like our Chief Justice, Dean Traynor has the rare mix of being an astute administrator and being a very distinguished and acknowledged scholar. W. Norton will soon publish Bill's upcoming book, Fathers of the Constitution, Triumph, Tragedy, and the Creation of the American Republic. I now hand over to Bill to take over this.
Well, thanks very much, Viva, for your very kind words. And I have to say, I have been looking forward to this event for so long. Viva, who's one of our alums, had the vision of strengthening the ties between Georgetown and the U.S. Supreme Court and the Indian Supreme Court. And we've had a series of conversations over the past few years. Justice Breyer had a conversation with Chief Justice Ramana last year. And I also had the privilege in 2017 of meeting the Chief Justice in a meeting in India, which was set up by Viva. So it's great. And I also want to thank Justice Breyer for being here. He's teaching tomorrow. He rearranged his schedule so he could be here. And I'm really just so grateful that we're going to have this conversation. Obviously, he doesn't need an introduction, but so I'm not going to do that. But I would just kind of 2 things that I'd highlight before I get into the substance. A lot of his scholarship while he's on the court have been on subjects that we're going to be touching on. So in particular, his book, Active Liberty, which has the vision that the constitutional principal goal is to encourage and support civic participation. I think we're going to be hitting on a lot of those themes. And also The Court in the World, which is about kind of reliance or invocation of other nations' constitutional jurisprudence and Supreme Court jurisprudence. So I think those are themes that we'll inevitably be talking about. Just, again, Chief Justice, Justice Breyer, so delighted you're here, so looking forward to this conversation. I'd like a round of applause for both of them. So I'm actually going to start on a kind of a biographical question. So Chief Justice, you studied at Harvard, and you told me that you audited Justice Breyer's course. Do you want to have any reflections on how any of this has influenced your jurisprudence? Oh, I think that's your microphone. Thank
you. My years at Harvard Law School were not just informative, but formative. The first thing that I learned at the law school was the emphasis is not on as much on teaching law as on thinking about the law. And I think that has been the critical standout feature that I picked up from the law school. Those were the emerging years of the critical legal studies movement that really now has branched out into areas like critical race theory. But I was really at that point when the critical legal studies movement was kicking off in our law schools, and particularly in structuring my own understanding of rights jurisprudence. My years at Harvard were tremendously life-changing. When I was doing my PhD, the SJD at the law school, I wrote an affirmative action. And one of the areas which I researched while sitting in the Widener Library was philosophical issues in affirmative action policies. I think this has left an indelible imprint in my own life. I guess the benefit of education is something which you realize in layers as you progress through life. So I think the benefit which I received when I was a student is very different from when I became a lawyer. And I would appear for bonded workers, for the HIV positive segment of our population, for religious and linguistic minorities. And then coming to my years as a judge, and I've been a judge for almost 23 years now in the system, I think it has, in very critical ways, changed the way I think and write about the law. For instance, ideas such as, what do you mean by merit when you talk of affirmative action policies? You define merit in terms of raw scores in entrance examinations to law schools or medical schools? Or do you define merit in a more broadly inclusive sense as putting those who have been marginalized in our societies in frameworks of decision-making responsibility to make our society more inclusive, more diverse, more plural? I think these are really ideas which have deeply influenced me. Or in terms of the work which we have done in the Supreme Court on gender, while talking about intersectional discrimination that women in particular face. So some of these ideas continue to shape the work which I continue to do. And I think in so many ways, my interface at the law school has been life-changing. Justice Breyer's lectures were simply amazing. And
Well, the amazing thing is, despite having gone through my course, he's made a success of himself.
And really, it was not just an unfolding of administrative law, but the unfolding of administrative law, and it's very deep connect with constitutional law, because this is something which we have witnessed in India as well. The growing constitutionalization of the principles of administrative law, by grounding those principles on fairness, on reasonableness, on doctrines of proportionality. So there's so much that really this education has meant to me.
Actually, let me just ask you, so a separate question. So you studied at Oxford before you started law school, Justice Breyer. Did that influence your jurisprudence at all?
My jurisprudence, most of the time at Oxford, you get up in the morning as late as possible. You'd find somebody who's having coffee or tea or friends in his room. You'd go over there and have a little discussion with your friends. Probably you'd go to lunch. In the afternoon, you'd go out and walk along the river. And my greatest achievement is you had to read your essay for the week to your tutor. And a friend of mine figured out that, which I tried for a while, but they weren't stupid and they figured out what was going on. I would just have a blank piece of paper. But I liked Oxford. I mean, it was great. It was great. But I didn't study law there. I studied PP. I studied philosophy, politics, and economics. And it stood me in good stead, particularly the economics and the philosophy. Yeah, it was good. I liked it.
It sounds fun.
It was. It was. I said that. I wrote to my parents in those days. I said, I think for the 2 years I was here, I enjoyed it. I enjoyed it. Well, I didn't go into detail, but there we are. Yeah.
So now back to the Chief Justice. So last week, major decision on same-sex marriage by the Indian Supreme Court. Would you talk a little bit about that and about your opinion?
Sure. Well, in 2018, we reversed a judgment of the Indian Supreme Court. And in 2018, by our decision, we decriminalized same-sex consensual relations between adults of the same gender or sex. And that was important in itself. But that was not the end of the evolution of LGBTQ rights in India. And we have this clutch of petitions which came up before us for hearing, where same-sex couples chose to espouse their right to marry under the Indian Constitution. Now, we have a legislation in India called the Special Marriage Act of 1955. And the Special Marriage Act was basically enacted by Parliament to allow couples, heterosexual couples, belonging to different faiths to get married under a secular law. Because prior to that legislation, there was no other choice except for one of the couples to, one of the two to convert to the other religion. But this gave you a secular option where you could continue with your faith and yet get married under the law. And the law obviously spoke about heterosexual couples, man and woman. It had different degrees of prohibited relationships for men, a separate set of relationships for women. But it doesn't end there, because marriage itself is governed by custom and then codified into statute. So you have statutes governing the relations, the marital relations between people of different religious communities in India, whether they are Hindus or they are Muslims or they are Christians, Zoroastrians, and other religious groups. So one of the key questions was, does the court have the jurisdiction to essentially get into this domain and to mandate that there is a right to marry under the Indian Constitution? By a unanimous verdict of all the 5 judges on the bench, we came to the conclusion that while we have progressed a great deal in terms of decriminalizing homosexuality and recognizing people belonging to the queer community as equal participants in our society, legislating on the right to marry is something which falls within the domain of Parliament. And we couldn't, by judicial fiat, enter into a very complex area, which is not just confined to marriage, but which goes into other areas like marriage, adoption, succession, inheritance, tax. Therefore, we said that, well, it's time for Parliament to act. Apart from that, that's where I got into a minority. I said, though we cannot, therefore, entrench into the domain of Parliament, nonetheless, there were sufficient foundational principles in our Constitution to allow for recognition of same-sex unions in terms of civil unions. And we grounded that in provisions of our Constitution dealing with the right of association, the right to life and personal liberty, the right to free speech and expression, and the right to conscience. Interestingly, the right to conscience is a part of the same right under which the right to freedom of religion is recognized. We held that conscience is something much broader than religion. It incorporates your right to follow your own faith, but conscience is incredibly vaster than merely your right to freedom of religion. 3 of my colleagues, another colleague joined me in this, but 3 of my colleagues felt that to recognize a right of forming unions was again beyond the judicial domain, and that it must be left to Parliament. So on the fundamental issue as to whether same-sex couples should have the right to form abiding unions and cohabitational relationships, 3 of my colleagues, though they recognize that they do have the right, they said we cannot elevate this to a constitutional right. The other area in which we were, again, I was in a minority of 2, was whether same-sex couples have the right to adopt. I said that, well, same-sex couples, queer couples, have the right to adopt a child, because under Indian law, 2 single individuals can adopt. A man can adopt a child, a woman can adopt a child. So I said, if they are together, there's no reason to deny them the right to adopt a child merely because they are in a queer relationships. There again, 3 of my colleagues differed. They felt that the absence of a recognition of the right to adopt to queer unions is discriminatory, but that's something which has to be addressed by Parliament and the delegate of Parliament while framing subordinate legislation, but that the court should not go as far as to do that. So on the broader aspect, there was unanimity, but on the right to form unions and adoptions, I was in a minority of 2 as against 3 of my colleagues.
So, and just to put it in context, so I think we were talking before, in the history of the Indian Supreme Court, there have only been 13 cases in which the Chief Justice has been in the minority. Is that what you told me?
Yes, that's right. Generally speaking, Chief Justices have not been in a minority, but there are 13 cases, significant 13 cases in our history where Chief Justices have been in a minority. And I do believe it's sometimes a vote of conscience and a vote of the Constitution. And I stand by what I said.
That's very good. So, Justice Breyer, the path to Obergefell. When I was in law school, Obergefell would have, I think would not have been conceivable, at least to me. And actually, my roommate wrote a paper essentially arguing that there was a constitutional right to same-sex marriage. And he went to a lot of faculty members and they said, this will never happen. And yet it did. How did it happen?
5 people thought it was there and 4 did not, I think. But the interesting question is right for homosexual marriage is not, I don't find it written in the Constitution. The words that are there that were significant are, no state shall deprive any person of equal protection of the law. Now, think of those words for a moment. And if you think of the words, and we're now in a situation, I'm just writing something about using words in the Constitution or in a statute. And as you know, there are many more people now than when I was in law school that think that what court should do is look at those words and then stop. Or look at what the words meant originally to the people who wrote them and then stop. I don't. Well, Nino and I used to debate that. And I would say, I've just written, I will be out in a while. I don't know how much to go into this, but the reading the Constitution, why I chose pragmatism, not textualism. And of course, the real title of the book should be, While I'm Right and Everybody Else is Wrong. But, so you have a long explanation. But the short explanation, and it's more, we taught this last week, it was the equal protection of the law. Now, what's that about? Because a lot of historical scholars think that the equal protection cases, which you probably know many of them, Brown versus Board of Education, for example, really should have been under the Privileges and Immunities Clause. That would guarantee everyone being treated the same. Equal protection has this word protection. And it seems to mean that you will apply the law the same way to every person. And once you see that, you see why, from a purely linguistic point of view, Brown had a hard time coming along. Because as soon as they said equal protection of the law means similar laws, then you're back in Plessy v. Ferguson. Because they said, sure, you're going to have the same law, it just has to be equal treatment. I mean, of course. I mean, I'm old enough to remember that anyone who saw the pictures in Life magazine of a black person's school and a white person's school, if they thought they were equal, they would have to be out of their minds. I mean, they were no more equal than flying. But that wasn't a sort of legal issue. Okay, so Brown is then interpreted to mean you can't separate the races. No one school for black, no one school for white. And why not? Why not if the schools really were equal? Didn't have to worry about that because they really weren't equal. But suppose they had been. Say, now we're getting into this more deeply. And you say, well, if they're really equal, that must mean, that doesn't work. So what Brown really means is, no separation of races. And why was there not a big fuss about that? Of course, there was a big fuss in the South. But why? Because World War II had passed? Because people understood finally what was going on? And when they looked and saw what was going on, they said, no, we don't like it. That was the era of Martin Luther King. That was the era of the bus boycott. That was the era of the Freedom Riders going to the South. And it took 10 years, 15 years before we really got rid of racial segregation. Now, why do I go into all that? Because by the time the court got towards the end of that 15-year period, it began to say things such as, no, we're not going to have people treated differently because of race or religion or. And because that's what that equal protection clause means. And we're going to try to make that enforceable. We just spent 15 years trying to get it enforceable. My God, it's been terrible. But we have it, or we don't quite have it. I don't know. Well, in the law, we sort of have it. And anyway, that's a theory. All right, have you followed it that far, that confusing explanation I've just given? Because it's relevant to Obergefell. Along the way, the court wrote an opinion roughly on the question, but suppose a person has a religious belief that you should discriminate against minorities, because the Constitution does protect freedom of religion. And an opinion of the court said, if the reason a person has a religious belief not to do what the law says, well, that doesn't count if the religious belief itself is not based on something that will hurt themselves or hurt other people. Now that's important, because you have coming up in Obergefell, at least this is a sort of, you can begin to see the screwy way in which my mind is working. But nonetheless, you're getting in Obergefell a right to something that's terribly important to people. And you can go back to the 19th century and see Myers, where the court held there is a right to educate your children and teach them German or teach them what you want. And here, there is a very important thing to people, to marry whom they want. All right, what's the argument against it? And this was a little surprising to me. If you read through those 80 briefs or 90 briefs, there were really only two major arguments. One is religion. Religion, many religions thought it was a very bad idea, but we've just said, is it because it hurts people? They couldn't answer that very well. Does it really hurt people? The people involved doesn't seem to. Somebody else? Who? They made a big issue of that. Then they said, well, okay, what's your other reason for wanting it? Any others? Yes. Never been done before. Ah, yes, you laugh at that one, because the woman's place is in the home. I mean, that's what's going through Ruth Ginsburg's mind instantly. Never been done before. A woman's place is in the home. Okay, we got it. That didn't work. And if that's going to be your argument, it's never been done before. It's not going to hurt anybody. Doesn't seem, at least their argument's weak on that one. And what else? There wasn't much else in those briefs. So we have over here something that's terribly important to the lives of an individual. And something over here that isn't too strong. Well, that was enough to get the 5. Mm-hmm. That was enough to get the 5. And then you go back and say, well, what are these rights that aren't mentioned in the Constitution? See, Nino and I used to have big debates. If he were here, we'd get into a major debate. Mm-hmm. And he'd say, well, what are you doing, Breyer? This is ridiculous. He'd say, I'd say, of course you have to interpret the Constitution. So the rights within it change as circumstances change. And I would say, George Washington didn't know about the internet. And he would say, I knew that. and then he would say, I'm not saying that you're not in good faith. He understood after a while, I'm certainly in good faith. But he'd say, look, you have a way of interpreting the Constitution that is so complicated that you're the only one who can do it on your system. And it's going to be a god-awful mess if people follow the way you want to do it. And I would say, what if they follow the way you want to interpret the Constitution? You're going to have a Constitution no one will want. And there you have a sort of state of the argument. And moreover, it's a state of the argument right now, right at this very moment. And it isn't that one is obviously right and the other is obviously wrong. Obviously, this is why law school is so important. When I was in law school, I read Holmes. There's a kind of instinct, but more than that. You can't just go by instinct. You have to go by looking into the history to see what was important to people and has been over time and may change over time. And the rights do evolve over time. And then you have to look at a lot of things. Look at things like consequences. Look at things like history. Look at things like How related is this kind of a right to that? Look at things like, what did they think at the time they wrote it? That's surely relevant. Look at things like how circumstances have changed. Do you think Brown would have been written if it hadn't been for the Second World War? I don't. I think the Second World War, and suddenly we had black battalions and we had brave people, and Bill Coleman, who was a friend of mine during that war, was an officer and went into the officers' club and they wouldn't let him in. So he went to the commanding general of the base and said they wouldn't let me in. The commanding general said to him, and I think these words are important, do you really want to go in? And Coleman said, yes, I do. Very well, they're going to let you in. Now, you see how things are changing? You see how things are changing? Even in the South. No, not yet. That required a lot of work. And how many people helped? All right, I'm trying to give you, if you want to read what I'm trying to say, read Justice Harlan, Second Justice Harlan. Read Second Justice Harlan's description of what are the rights that the Constitution protects and how do we find them. It's written in a concurring opinion in Poe v. Ullman, the contraception case. And why does he think that contraception, which by the way is not mentioned in the Constitution, suddenly becomes something that does have some constitutional protection? Why? Or, you want something else to read? Read the British Supreme Court opinion in the case involving the prorogation of Parliament. See, they don't have a written constitution, but they have to decide and discover what it is that their law protects. They go back into history and they see how proroguing was used or wasn't used. It's a pretty good opinion. And at the end, it's fairly convincing. All right? All that's there. All that's there. It's not that you just sit there and say, oh, it would be a such good thing if, in fact, you could have homosexual marriage. No, that's not the job of the judge. The job of the judge is go back, look at the history, look at the words, look at the consequences, look at the values that underlie the words that are written in the Constitution, and then, I don't want to say guess, but I do want to say, there is a thing called judicial instinct. And that judicial instinct is not just for judges. In one of the better articles I read when writing this, it said, look, I want to flatter the dean, or maybe you. And I'll say he's a brilliant person. She's really brilliant. That's great for a teacher, not for a judge. Not for a judge. The word of flattery is, and what you hope to achieve is, an opinion that is sound. And that's good for lawyers too. He's a lawyer who has sound judgment. She is a lawyer who will, in fact, lead the client on a path that will turn out to be sound. That judge has written an opinion that's sound. It means it works for the country. It means it's connected with the past. It means it channels into a future which is more likely. And if you think that there is some dictionary you can look that up in, no, I don't. I don't. And when will we know if I've really, or any judge has really, or any lawyer has really given advice or written an opinion that is sound? And the answer is that judge will never know. It will be 20, 30, 40 years into the future when people will look back, as we're pretty sure they will with Brown v. Board, and they will say, thank goodness the court understood the public and understood the law well enough to reach that result. Does that mean politics? No. Does it mean no politics? No. Well, what does it mean there? Paul Freund explained that very well. He said, in terms of politics, no judge ever should decide something based on the politics of the day. But the climate of the year, that is something different. And the interesting question right this minute for you is, where are we on that? Where are we? What's going on? What should go on? Where do you actually disagree? And if you actually disagree, why? And you find somebody who disagrees with you, and then you say why, and you listen to them. And eventually they'll come around to something you believe in. Let's work with that. That was Senator Kennedy I worked for. Let's work with that. And then that's what this country, I think, is good at. We're good at getting people who think different things and trying to get them together. And it wasn't just one group or another that brought food to the old people during COVID up in Cambridge. And it wasn't just Cambridge. It was St. Louis, it was Los Angeles, it was San Diego, all over the place. Okay, I've said enough to pose a question for you. And I hope in 2 or 3 years, or whatever year you're in, by the time you're out of here, you won't have a definite answer. But you will have an informed way of criticizing or praising the decisions that are written by the courts and the advice that is given by the lawyers.
That's terrific. Very powerful and thoughtful answer. So, Mr. Chief Justice, you came out in a different way on the same-sex marriage. You know, what led you to a different result?
Well, when I grounded my opinion, I looked at fundamental constitutional values. And to my mind, what is the morality which a judge imbibes and gives expression to while deciding cases? Do you give effect to a social morality? And to my mind, the answer is clearly no. To my mind, what a judge decides while interpreting the Constitution is a sense of constitutional morality. And constitutional morality is something which is grounded in the fundamental values of the Constitution. And what are those fundamental values of our Constitution? Those fundamental values are liberty, equality and equal protection of laws, the right to free speech and expression, and above all, fraternity. And our Constitution speaks of fraternity, meaning thereby that it postulates the equality, the brotherhood, the unique oneness of our civilization. And therefore, to my mind, when you interpret the Constitution as a living or organic document. We have, in India, don't have this debate on whether we should interpret the Constitution from the perspective of what it was intended to be when it was adopted. But how has the Constitution unfolded itself? What is the backdrop in which the Constitution was born? Our Constitution was born not merely as a document to witness the transfer of political power from a colonial regime to a homegrown regime for independent India, but together with the movement for the transfer of political power to an independent regime, there was something more fundamental which was going on. And that was that the Constitution was always intended to be an instrument of social transformation. You had groups of Indian citizens, whether based on caste or patriarchy, who were deprived at the birth of the Constitution of fundamental human rights. And therefore, the Constitution had a clear vision, a vision which would mark the Constitution not just as a political document, but as a document which would witness a social transformation. And therefore, to my mind, as a judge, I'm a judge in today's times, contemporary times, but I would join Justice Breyer in saying that as judges, it's our duty fundamentally to look at the histories of discrimination which our people have suffered and to use the Constitution as a peaceful means of bringing about a social transformation. In so many societies across the world, you find that the rule of law has given way to the rule of violence. And the key to a stable society is the ability of judges in that sense to use the Constitution and their own platform as a platform for dialogue, as a platform for reason, as a platform for deliberation. And in so many cases that we decide, including the case that we have been speaking about, I think our outcomes are in themselves important, but the process is itself as important as the outcome. Because in the process of constitutional deliberation that goes on in the court, you foster a new and emerging consensus. And in that consensus which emerges through the process of judicial deliberation, we put out a hope for a better future for our societies. Now, obviously, you cannot have a sense of unanimity on key constitutional issues which we decide. And there's a reason for it, because I do believe that we as a court reflect the diversity of our nation, the diversity of our cultures, the diversity of our own individual backgrounds, and therefore bring to the table different ideas based on our own experiences of life. You can't take it away from a judge. But above all this, I think the one key factor is to understand what the Constitution really intends to be. Because just as our societies are constantly in the process of evolution, in the process of flux, there are certain values in that sense, constitutional values, which must be eternal to the existence of our nations. And it is on those values that democracy and the rule of law ultimately survives and thrives. I believe that judges have a very vital role to play, though we are not elected, though we don't go back to the people every 5 years to seek their votes. But there's a reason for that. And the reason for that is I do believe that the judiciaries are, in that sense, a stabilizing influence in the evolution of our societies, particularly in something like our age, which is so rapidly changing with technology. And we represent, in that sense, the voice of something which must subsist beyond the vicissitudes of time. And in that ability of courts to exercise a stabilizing influence, I do believe that we have a role to play in the overall stability of our own civilizations, of our own cultures, particularly in the context of a plural society such as India.
So, I mean, what a terrific answer. So, thinking about the same-sex decision, it seems to me that there are two things that you're doing. One is when you're in the minority, your position is that civil union and also the adoption are essentially so well established and clear that it's the role of the court to recognize them, but that there's also a dialogic function, and so I read your opinion to be supportive of same-sex marriage, but to say, but this is really, I've told you what I think, but this is a matter for the legislature. And so there's a kind of a dialogue that I see going on. So Justice Breyer, do you think of courts as in dialogue with the people or with Congress? And if so, when?
Easy to say yes, but I don't really think so. They don't read it. I mean, very few. You read in the newspapers some major decisions, probably 40%, 50%, 30% every year unanimous. And we'll take cases, most of the work is where the lower courts have come to different conclusions as to the meaning of the same words in a statute or the application of the Constitution. You may have a case like we had a case, whether the comma that precedes the word for in the Internal Revenue Code means that word for could be interpreted as a which or a that. Now, why would we take that? Because different judges have come to different conclusions on that same question. So we had to decide, does the comma mean which or that? Now, I like the case, no one else did, but I mean, it's a wide range of things. All right, and when I worked in Congress, which I did for a while, one day I get a call from Chief Justice Breyer. I'm a staff person. At some point, I remember, why is he calling me? He's the Chief Justice of the United States. But I work that way. No one else would talk to him. They're on a different time schedule. They are on a different daily basis. Look, this is Congress. I go into my office over there, and there's a young woman from one of the universities here, and she's going through all the papers on my desk. I said, excuse me? I said, how do you happen to be going through all these? She said, oh, I was curious what you did, so I thought I'd look through all your papers. So I was getting a little annoyed. But just before revealing how annoyed I was, I thought, maybe she's a constituent. Mm-hmm. You see, that's Congress. That's not the courts. The courts would take a long time, 3 months, 2 months, 3 months to try to figure out the answer to this thing. They don't have that time. If Kennedy received 2 phone calls, one from the mayor of Worcester and one from the Secretary of Defense, and he has to take one or the other immediately, I know which one he's going to take. He's going to take the mayor of Worcester. Of course, they're in his constituency. All right, it's a different world. And once we've tried with Brookings to send, well, we thought they made a mistake, just a mistake in drafting, and send it over there so they can correct it. And sometimes that works. I can't, don't say I'm saying zero. It's not zero. I mean, there is in the longer run some kind of a dialogue, etc. But you don't feel it day by day. But not that that matters, but you don't. But you hope in the longer run somebody will read even the which or that opinion. And there will be people who are expert over in IRS, and they will read it. Oh, here it is. Yeah. When they read it, next time they won't write for, they'll write comma or something like that, and things will gradually improve over time. Okay, but that's, I think, a more realistic, based on my own experience, account of this relationship, which is a tough one.
Any reactions, Chief Justice?
Well, looking at our cultural and social background, I do believe that courts today have become focal points of engagement between civil society and the quest for social transformation. So people approach the courts not just for outcomes. Let's be very clear, people approach the courts also for a voice in the process of constitutional change. And I do believe that by giving a platform, a public platform, for that voice for social change, courts in and of themselves are performing a very vital function. Why is that happening? Why are people increasingly coming to the courts to voice opinions, ideas, aspirations for change? That's a complex question. A variety of reasons for that. But it's very important for courts because we are as much institutions of governance, governed, of course, by principles of the separation of powers. So we don't take upon ourselves the role of the legislature, or we don't take upon ourselves the role of the executive. But equally, though we are bound by fundamental principles of separation, we are becoming areas where people come in order to give vent to their expression for a society which they aspire to achieve, whether it's in the area of human rights, of climate change, of social welfare. And particularly because sometimes events which are taking place in society are taking place with such rapidity that courts in that sense have that sobering influence in areas where the winds of change are blowing rather fast. Because when the thunderstorms are approaching and we have storms and we have clouds across global societies, because one of the problems of a very interconnected world in which we live is that these interconnections really ensure that we don't live as nations in silos. Therefore, courts have a very vital role to play in that sense, in steadying the ship when so much perhaps is happening all around our societies.
So, Justice Breyer, So one thing I'd like to go back to, when you were talking about Brown, I thought when I heard you say that the way in which it transformed society was not kind of the doctrine, but the result. In other words, it was something that probably should have been decided under privileges and
The doctrine
immunities.
was okay, but I mean, you see, it led to problems and problems. This is a long thing, so I'm not going to go into it. But I think the way it's written, and I don't know how else it could have been written, given the destruction of the privileges and immunities clause. I don't know how I would have done any better. I wouldn't have. But it then led to this affirmative action problem. You see, because it provides a basis, the way it's written, for saying no racial discrimination, pro-black, pro-white, pro-anything. Now, I've written opinions on it. I don't agree with the way the court came out on affirmative action, but that's another story. But that's so. What is your point? That you have assumed that we are in the Supreme Court an institution of the federal government. It's not a law school. It is not, that's why I said it's not just politics. That's wrong. Anyone who thinks it's like that woman in my office who was going through my papers is wrong. That's not how it works. But it's not politics either completely. All right, so where are you in that? And that's something that takes a while to look at the different opinions. And Freud, as I said it correctly. Not the politics of the day, never. But this is popular, forget it. If you're sitting over there thinking that you're going to become very popular, even with the group that normally supports your opinion, forget it. Take a different job. You will not come away having enjoyed that one. Because of course you can't do that. It's impossible. And don't go near it. But if you like, and President Clinton said that to you at one point. He said, the applause goes away and you're left with the job. So you better like it. That interesting. And what is that? It takes a long time to explain what I think that job really is. So read the opinions, etc. Can I give one piece of advice?
Absolutely.
Go to India. We loved it. My wife was on this thing called, what was it? It was about research on women. And the woman who ran it, Gita, was Indian. And we went over there several times. We went over there. It's fabulous. I mean, it really is if you haven't been there. The people have a good sense of humor. They're all different. They like to talk. I like and they have really good food. That was the only problem. I had an Indian law clerk who was great. He had only one problem. He was marrying someone, and he came in one day looking very gloomy. And I said, "What's wrong? What's wrong with her?" He says, "Well, my mother is worried that she will not know how to make a samosa." So I said, "Well, she doesn't know." He said, "No, he's found it. She knows. She knows how to make the samosa." He told his mother. They lived happily ever after. Okay. So there we are. And it's very interesting hearing that these are pretty similar problems and difficulties that they have in the judiciary there.
Actually, I want to go back on affirmative action. So, that's a case in which, and first of all, you should all go to India. That's absolutely fabulous. So the Indian Supreme Court has a different position than the current Supreme Court of the United States. And it's in part grounded in your history and in the response to the caste system. So would you talk a little bit about kind of where the Indian Supreme Court is and how it came out that way?
Let me begin by telling everyone here that unlike the United States, our Constitution entrenches the principle of affirmative action. There are specific provisions of the Constitution which follow closely upon the provisions for the equal protection of laws. These provisions entrench affirmative action. Now, the argument against affirmative action in India, as well as in the United States, is that affirmative action detracts from merit. And the argument against affirmative action is by having quotas. We have quotas in education, in employment, and in political representation. So let me first preface the point which I want to make by telling you what the argument is. And the argument is that by having quotas or having affirmative action, you are essentially choosing people who are less meritorious. But this is an area which we have worked on considerably, because what you really mean by equality itself, you can look at equality as a sense of formal equality, or do you look at equality as something more fundamental in substantive terms? Because if you look at equality merely as formal equality, then by being colorblind or by being blind to the histories of discrimination which our people have suffered, you're essentially giving weight to the social, cultural, and economic capital which the privileged have acquired over generations. So in order to have a level playing field for those communities in our societies who've suffered from centuries of discrimination, affirmative action in that sense is not an exception to equality, but is a reflection of the principle of substantive equality. Second, you have to redefine what you mean by merit itself. Does merit factor into account the social, the cultural, or the economic advantages which the resourced in society have? Or does merit in that sense have to be redefined to provide for a more inclusive society? If you define merit in terms of inclusion, namely the importance of allowing people who have suffered from histories of discrimination to assume more important roles of decision-making responsibility in our societies, then you have the answer to your question. So it really depends on how you frame the question. If you frame the question in terms of formal equality, you will have a different answer. If you frame the question in terms of substantive equality, and I believe the latter is more correct, because our constitutions were not, in that sense, blind to the need for social transformation. And if our constitution is not blind to the need for social transformation, then the way we define equality or notions such as merit would really furnish us answers on which is the way forward. And it's not enough to say that, well, the way we interpret our laws or the Constitution must be colorblind or oblivious of skin color. Because underlying all that is that all that comes with a lot of accumulated disadvantage. But our task in India has been a lot simpler, I believe, because in that sense, we do not perform a counter-majoritarian function. In so many which ways, judicial review is regarded as being counter-majoritarian. Of course, we also exercise a counter-majoritarian function when individuals stand up against a violation of rights. But in so many which ways, India is a little different because those who have suffered from histories of discrimination are not necessarily in a numerical minority. They represent the heart of India. So in that sense, the courts, by giving effect to fundamental constitutional principles, are seeking to remedy these histories of discrimination which our own citizens have faced. And therefore, in terms of affirmative action, we have and we continue to give a very strong support to affirmative action policies right from the birth of the Constitution and thereafter continuing to the present.
Justice Breyer, that's a very different than the Baki approach. In other words, the justification for affirmative action is not, as in India, about leveling the playing field, but it's about kind of creating a diversity of voices. And the Supreme Court has rejected that. What are your thoughts on, you're a champion of affirmative action.
Look, Brown, a very interesting thing to read. You want to read something interesting, read Thurgood Marshall's argument. And why I found it so interesting, it hardly says anything about the meaning of the Equal Protection Clause. He thought every one of those judges thinks that racial discrimination is wrong and against the Constitution. And he was right, basically. I mean, you'd have to be an idiot not to see, as I said, what was going on. All right, but then what's his problem? They're thinking that if we say, read Holmes at the turn of the century, if we say that you have to enforce the 14th Amendment, or you have to treat people equally, or you have to let black people vote, that's Holmes. They won't do it. It's not the black people who won't do it. It's the white people who won't let them do it. That's what's going to happen. And Marshall is telling them, look, we can do it. We can do it now. You can get this enforced. You can get it enforced. Well, go look at the history of the next 15 years. Yeah, they could get rid of legal segregation on the law, and then read a good book that I'd never read, W.E.B. Du Bois. Have you ever read it? Read it. And you will see what happened after the Civil War. You will see the history of what went on for 80 years. And you will see, when you go then to Brown, yeah. Frankfurter said to Phil Elman, his law clerk, when Vincent died, because Vincent thought they shouldn't have a Brown v. Board. And when Vincent died, he said, now I know there is a God. Well, it took them a long time. And you read through that in the history of the country and so forth. I once asked Vernon Jordan, who was a great civil rights leader, do you think Brown really made a difference? Or do you think that it would have been, we've been in the same situation anyway with all of the civil rights leaders? And he said, of course it made a difference. Of course it did. He's at the very least a catalyst. All right, now, that's, in my opinion, basically what Brown is about. Can this court get up and say what they know? All right? And how long will it take? And will Congress help them? Answer, no, they didn't help them one little bit. And what was the key moment? In my mind, it was Eisenhower deciding to send those 101st Airborne troops, the ones who had landed on the church steeples in Normandy. Everyone knew who they were at that time. The ones who were the heroes of the Battle of the Bulge. Send them to Little Rock to be sure integration goes on, which it didn't. They had to leave. And then back to the court. And then the court says, no, integrate. And then they close all the schools. And then we have Martin Luther King and the Freedom Riders, and then gradually we begin to get rid of this legal segregation. You see, I say that because that case is about the country. It's about the country more than it's about some principle of law. And now, just now, they're beginning to, or perhaps wrongly, perhaps rightly, but extract various principles of law from that. And I still, when I wrote on this, which was 10 years ago, I guess, I said, I want it still to be about the country. And we don't know what's going to work. And we want to bring people into this country. It's not India. It's not 1.4 billion, but it is 340 million or 334 million. Let me not exaggerate. And 334 million people of every race, every religion, every point of view. That's a challenge. That's something. And he understands that perfectly well. And Howard is, I wrote in the opinion, let people try different things. They want to try affirmative action, let them try it. And but we're down in the begin with all right, I won't go into all of that. I will just say what you're seeing right now in front of you is people going into cases, into whether they said this thing or that thing in there. And I think it's still a question of what kind of country do we want in the United States of America? Because the Equal Protection Clause was bringing people in, not keeping them out. And I think there is a big difference there. All right, that's too long. I can't do this in less than 2 or 3 hours, but but you get an idea?
That's right. And we'll have you back. So we have time for a couple of questions, if we have questions from our audience. Yes.
So my question is more on the context of judicial appointments between US and India. If you talk about US, it seems that they have more like a lifetime appointment system versus the mandatory retirement age, which we notice in the Indian context. Justice Chandrachud, would you like to give your comments on whether that is something, given the judicial vacancies, is that something which we should consider, or that's not for us?
Well, in our high courts, we retire at the age of 62. And in the Supreme Court, the Constitution tells us that we retire at the age of 65. Speaking for myself, I do believe in the importance of an age of retirement for judges. Maybe that's the way my mind has been trained, because that's how we have learned the Constitution, and you're ingrained with these ideas. But from a purely theoretical construct of constitutional law, I think it's important that we must allow, and that is really in that sense a virtue of our system, that we allow for succeeding generations of judges to assume the mantle of decision makers, and therefore to correct us if we were wrong. And I think that's a very powerful statement of the theoretical construct of our Constitution. The second thing related to your question is that we've been criticized very often as being a polyvocal court. So we are 34 judges in our court, and we sit in panels of 2 or 3 where we exercise appellate jurisdiction. We are a final court of appeal, but we sit in larger panels of 5 or 7 or more when we are deciding important constitutional questions. But I do believe the polyvocality of our court, far from being a source of weakness, is in that sense a sense of strength to the institution of judicial review itself, because it allows for greater flexibility. We, of course, follow principles of legal certainty when we say that benches of 2 are bound by co-equal benches, unless you're overruled by a bench of 3. But inbuilt in our system, including on what you said, namely an age of retirement, is the postulate that it's important that we must have a certain degree of flexibility for change, which I believe judges who lay down office at a certain point of time leave for the future. Because we must make that allowance for the future to self-correct our own mistakes, or perhaps look at a future society.
Justice Breyer, should we have a mandatory retirement age? If you could start from scratch?
It would be better for the judges. It would have been easier for me if you had a term, but it has to be a long term here. You don't want somebody sitting over there thinking about what his next job is going to be. And so I've said 18 years, I don't know, 20 years. Does it matter if you have some long term like that? No, I don't think so. I think it would be better for the judges, frankly, but not a short one. Not short, but at an age, fine.
And better for the judges in what way?
You wouldn't have to worry about whether you're going to retire or not. I mean, you haven't faced this because you're such a young man. When I was 84 years old, I had to think about this pretty hard. I said, 84 now? I said, no, 84 is the new 18. But I know, I had to think about it fairly hard. And if there would have been a mandatory retirement age, I wouldn't have had to. I would save me wear and tear. My wife would have saved her a lot of wear and tear.
Mr. Sood?
Good afternoon, Chief Justice Stephen Breyer. My name is Udit Sood, and I'm a 2011 graduate from Canada and a 2015 LLM from Stanford Council. I currently work with Georgetown Law based out of San Francisco, although I'm not here in professional capacity. I'm here just as a meeting. My question is for the Chief Justice. In Loving v. Virginia, the U.S. Supreme Court held that that marriage is one of the basic civil rights of man, and on that basis, the court struck down Virginia's anti-miscegenation law. I've long viewed cases like Dhananjanaya and Shakti Vahini as India's Loving. These 2 cases involved interference by state and non-state actors in the marital relations of intercaste and interfaith couples. Our Supreme Court then had no hesitation holding that the right to marry a person of one's choice is integral to Article 21 of the Constitution. the right to life. The court enjoined state interference and even issued directions to the state to take affirmative steps for the protection of these couples. Now, with last week's ruling in Supreme, the court has unanimously held, one, that there is no fundamental right to marry, and two, Supreme has held that the Constitution of India does not in fact enjoin the state from restricting choice of marital partners based even on ascriptive core identities of citizens. Does this mean that a Virginia-style anti-miscegenation statute would today be constitutional in India? If not, what constitutional grounds might an aggrieved interracial couple invoke to challenge such a law?
Justice is one of the petitioners in the case.
Oh, Udit, I'm told that you are one of the petitioners in the same-sex marriage case. Let me frame my answer like this. In my judgment, I have specifically said that there are certain values in a marital relationship which find an emanation in fundamental constitutional values. And I've emphasized the right of choice, the right to choose your own partner, the right to cohabit with a person of your choice, and therefore the right to find someone with whom you want to live your life or to be a part of your own emotional, psychological, and social being as a partner. So I do believe that in my judgment, I have given vent to those basic aspirations of constitutional jurisprudence. Having said that, it becomes far more within the realm of judicial review when you look at and apply the anti-discrimination principle. If the state were to enact a law which specifically discriminates against marital choice or the choice of a person to marry outside your caste or outside your religion, that would be amenable to judicial review, applying well-established standards of equal protection or due process, which we've now read into the right to life and personal liberty. The difficulty which judges face is, in the absence of a statutory regime, do courts have the authority in a system wedded to the separation of powers to create an alternate statutory regime? So it's far easier for the courts to wield the power of judicial review when you're applying a piece of legislation which is discriminatory, as opposed to an appeal to the court to laying down an entirely new legislative regime. Going back to the same-sex marriage case, there was a challenge in that sense. We were told that the Special Marriage Act is discriminatory because it applies only to heterosexual couples. Now, if the court were to strike down that legislation, the consequence would be, as I said in my judgment, the consequence of that would be that you would be going back to the position as it obtained even before independence, which was that there was no legislation at all for people belonging to different faiths to get married. So striking down legislation, which is really the classical power of judicial review, would not be adequate in itself, because you'd be coming out with a prescription which is worse than the disease itself. So what does the court then do? Does the court have the power in a democracy or in a system governed by the rule of law to lay down new legislative mandates? That's where the difficulty really arises. Can the court, in that sense, fashion a new legislative ordering? Or does that court then defer to the legislature? In several comparative law jurisprudence, or several comparative law areas that we considered in our judgment, we found, for that matter, that the legislature had, in graduated steps, intervened to protect the right to marry of same-sex couples by legislating for a union, a civil union, as in the UK, and then eventually recognizing the right to marry. So for judges, it's more within the ken of judicial review if you are confronted with a statute which can be brought within the fold of the anti-discrimination principle, as opposed to a plea of fashioning entirely a new legislative regime of rights. And that's where really the core of the problem which courts face arises. Can you create a new regime for succession? Can you create a new regime for tax? Can you create a new regime for social welfare benefits? Because these are not areas which stop merely at the declaration of a right. But following a declaration of the right, the remedies which are sought are clearly within the province of the legislature.
So any reflections on that, Justice Breyer?
Well, that was one of the arguments. I mean, that was there, and we've had probably more experience with discrimination against women, where the denial of equal protection, and you say it's going to add a word, and so just add a word, and that's been criticized. It's been criticized quite a lot, but it's pretty well established. And so that part of it is a little easier for us.
So can I?
You may have missed that, but I'm not going to repeat it.
So I think we're actually right at the time.
Can I just add one? Can I just
Yes.
Can I just add another thing to this? For instance, where we have dealt with issues relating to gender. For instance, the exclusion of women from the armed forces, from being granted permanent commissions. We found it much easier because we struck down a provision of regulatory conduct which prevented women from joining the armed forces. And we said that was clearly discriminatory. And therefore, you must allow women to enter into the armed forces. Or where we provide for the medical termination of pregnancies. We have a law in India which says that a woman can have a right of termination of pregnancy up to 20 weeks in certain circumstances. And that's extendable to 24 weeks for married women. Well, we struck down the distinction between unmarried and married women by saying that there's no rational distinction to distinguish between unmarried women who want to terminate their pregnancy and married women who are given the right to terminate pregnancy. So we extended effectively the period from 20 to 24 weeks by applying the common yardstick to married as well as to unmarried women. So where you're in the realm of discrimination, the courts have a far wider scope for expanding their jurisdiction in such cases, which I thought I'd just highlight in the context of gender.
I said, this has been extraordinary. What a privilege to be able to hear from the Chief Justice and Justice Breyer in such a free-ranging conversation about constitutional law. So first of all, I'd like to thank Viva and Dean Vasquez and also Dean Sender for helping make this possible. And I'd like to just a big round of applause for our speakers.